All right, let's dive into a Supreme Court case that's generating some buzz, to say the least. United States versus Haymond.
Yeah, this one's a real head-scratcher. It gets right at the heart of some pretty fundamental questions about sentencing and supervised release.
The crux of the issue, and I'm sure many of our listeners are familiar with this already, revolves around mandatory minimum sentences.
You got it. The question is, can a judge impose a mandatory minimum sentence when someone violates the conditions of their supervised release? And specifically, does that square with the Constitution?
We're talking about a situation where someone's already served their time for a crime, they're out on supervised release, trying to reintegrate into society, and then bam, they're hit with more prison time because of a violation.
And not just any prison time, we're talking mandatory minimums, which can be pretty hefty, all because of a judge's finding, not necessarily a jury verdict.
So let's unpack this whole thing, starting with the details of the case itself, United States v. Haymond. What are we dealing with here?
Okay, so we've got Mr. Haymond, right? He served his sentence, got out on supervised release, and then a judge determined that he possessed child pornography.
And that determination, if I'm following correctly, was based on the preponderance of the evidence standard.
Exactly, meaning the judge found it was more likely than not that he possessed the material, which, as you can imagine, is a pretty serious violation.
And this violation triggered a mandatory minimum of 5 years in prison under this particular law, 18 U.S.C. section 3583K.
5 years, no ifs, ands, or buts. That's where things get dicey.
Because the big question here is whether this mandatory minimum sentence imposed by a judge based on a preponderance of the evidence clashes with Haymond's Sixth Amendment right to a jury trial.
That's the constitutional knot the Supreme Court's trying to untangle. And as we dug into the oral arguments, it became pretty clear that the justices were really wrestling with two major precedents, Apprendi v. New Jersey and Alleyne v. United States.
Cases that deal with the jury's role in determining facts that can increase a defendant's sentence. So the justices are essentially trying to figure out if this supervised release situation fits under the umbrella of Apprendi and Alleyne.
Exactly. They're trying to see if the principles established in those cases about when a jury is required to make certain findings apply to this specific context. And they were also grappling with the distinction between supervised release revocation and parole revocation, two very different beasts.
And on top of that, they raised concerns about whether someone could end up serving more time in total than they could have under their original sentence, all because of a violation during supervised release.
Which, of course, has major implications for the entire system of supervised release, which is supposed to be about reintegration and rehabilitation.
All right, so with that backdrop in mind, let's get into the meat of the arguments. First up, the government's position, laid out by their lawyer, Eric Fagan. What was his main line of reasoning?
Fagan's core argument was that revoking supervised release is basically the same as revoking parole. And with parole, there's no constitutional requirement for a jury to find a violation beyond a reasonable doubt.
So he's drawing an analogy saying these two types of release, supervised and parole, should be treated the same way legally when it comes to revocation.
Right. And he emphasized that Mr. Haymond's original sentence, the one a jury actually authorized, included 10 years of supervised release as a possibility. So in the government's view, this 5-year re-imprisonment was still within that 10-year window that was baked into the initial sentence.
Essentially saying, look, the judge isn't imposing a new sentence, they're just enforcing a sentence that was already on the table.
Precisely. Fagan also argued that the judge's finding wasn't about a new crime or a new element of the original crime, the kind of thing that would usually trigger Apprendi and the need for a jury.
So their argument is this wasn't a finding of new criminal conduct, it was simply a finding that Mr. Haymond violated the terms of a pre-existing sentence.
And they tried to distinguish this situation from those where a judge's finding could lead to a sentence exceeding the maximum that was originally allowed for the underlying crime.
Which makes sense, right? If the judge's finding pushes the punishment beyond what was originally authorized, that seems like a much bigger constitutional problem.
You got it. They also made a point about Congress's shift away from parole, arguing that it doesn't really affect the legal analysis here.
So they're basically saying whether or not parole exists anymore doesn't change how we should look at supervised release revocation.
Yeah, and they argued that Apprendi is grounded in the Sixth Amendment, which deals specifically with criminal prosecutions. They claimed revocation proceedings aren't new prosecutions, they're just about enforcing the terms of an existing sentence.
But even if that's the case, I imagine the justices had some questions about fairness, about due process.
Oh, they did. They push back, especially on whether such a significant consequence, 5 years in prison, could be imposed without a jury's involvement. Fagan conceded that in extreme hypothetical scenarios, like imagine someone facing the death penalty for a supervised release violation, there might be due process or Eighth Amendment concerns.
So acknowledging that those constitutional protections might come into play in truly extraordinary situations.
But he stuck to his guns, arguing that the Sixth Amendment's right to a jury trial wasn't necessarily triggered in this case. He also defended the use of the preponderance of the evidence standard for all supervised release revocations, whether it's a mandatory minimum situation like Mr. Haymond's or a more general violation.
And what was his justification for using that lower standard of proof in all those cases?
He kept circling back to this idea of a breach of trust. He argued that when someone agrees to abide by the conditions of their supervised release and then violates those conditions, it's a betrayal of that trust. And the sanctions, whether a mandatory minimum or something else, are meant to address that breach.
So the government's saying, look, you agreed to these rules, you broke them, there have to be consequences, and those consequences don't necessarily require the same level of proof as a brand new criminal charge.
Right. And they also tried to downplay the whole mandatory minimum problem under Alleyne. Remember, Alleyne says judges can impose mandatory minimums based on facts they find that increase the penalty beyond what a jury found. But Fagan argued that in this case, the mandatory minimum was tied to the violation itself, not some new factual finding about the original crime.
It sounds like they were trying to draw a very fine line there.
They were. Now let's flip sides and look at the arguments made by William Lund, lawyer representing Mr. Haymond.
What was his main thrust? His counter-argument to the government's position?
Lund went right at the heart of the matter. He argued forcefully that the mandatory minimum sentence under 300-583K, the one at issue here, absolutely increases the punishment for the original crime based on a facts found by a judge, and that's a direct violation of Apprendi and Alleyne.
So he's rejecting that whole line-drawing exercise the government was attempting.
Completely. He hammered on the distinction between supervised release and parole, arguing that when supervised release is revoked, sending someone back to prison, it feels much more like a brand new punishment, not just the loss of a conditional benefit.
Which gets back to that point we were talking about earlier about whether this is more like losing a privilege or facing a new punitive consequence.
Yeah, and several justices seemed receptive to that distinction. Lund also pointed out that under this particular law, 3583K, it's even possible for someone to face life in prison without parole after a supervised release revocation. And he argued that the potential for such an extreme consequence creates massive due process and jury trial right problems.
Because imagine that, facing the most severe penalty in our system, life without parole, not based on a jury verdict, but on a judge's finding using a lower standard of proof.
That's the nightmare scenario he was laying out. Now, he did concede that the more general revocation and reimprisonment provisions under 3583 might be okay in many situations, especially when the new prison term doesn't exceed the original period of supervised release and is focused on rehabilitation.
So he's drawing a distinction between those more garden variety revocations and these mandatory minimum cases where there's no room for individualized consideration.
Exactly. And he emphasized that if a specific fact, like possessing child pornography in this case, automatically triggers a higher mandatory penalty, then the Constitution requires that fact to be proven to a jury beyond a reasonable doubt.
Which goes back to that core principle from Apprendi, right? Facts that increase punishment have to be found by a jury.
Exactly. Yeah. And he argued that a mandatory minimum does exactly that. It ratchets up the punishment based on a judge-found fact. He even brought up some historical context, pointing to the initial version of the Sentencing Reform Act, which allowed judges to use their contempt powers to deal with violations of supervised release that involved new crimes.
So he's saying there's a way to handle these violations without resorting to mandatory minimums that exceed what a jury initially authorized.
Right. And his point was that this contempt power approach could have addressed those violations without blowing past the original incarceration period that the jury had signed off on. He also argued that while conditions of supervised release aren't considered elements of the original crime under Alleyne, when you slap a mandatory minimum sentence on top of a violation finding, it effectively aggravates the punishment for that original crime. And in his view, that creates a kind of new element that should require a jury's determination.
He seems to be saying you can't just call something a condition and bypass the jury's role in determining punishment. If it increases the potential sentence, it should be treated as a new element requiring a jury finding.
That's the essence of his argument. And he expressed a broader concern that allowing these mandatory minimums in revocation proceedings undermines the whole point of the jury trial right and gives way too much power to prosecutors in the post-conviction phase.
It sounds like he's painting a picture where prosecutors can essentially circumvent the jury's role by loading up conditions on supervised release and then using those to trigger mandatory minimums later on.
That was his worry. And he addressed the practicality of having jury trials for revocation proceedings head on. While acknowledging that theoretically a jury could decide whether a violation happened and address those Apprendi and Alleyne concerns, he raised a bunch of real-world hurdles.
Because as you can imagine, a full-blown jury trial for every supervised release violation would be a logistical nightmare.
Absolutely. He pointed to questions about the burden of proof, the defendant's right to confront witnesses, potential double jeopardy issues, and self-incrimination concerns. He also warned that if the court upholds 300 and 383K, it could open the floodgates, leading to mandatory minimums being applied to all sorts of minor violations, which could lead to wildly disproportionate sentences.
It sounds like he's saying, be careful what you wish for. If you go down this road, it could have unintended consequences for lots of people.
Exactly. And he wrapped up by emphasizing the traditional purpose of supervised release, which is to focus on the individual's needs and promote rehabilitation. He argued that introducing this more adversarial system, with mandatory minimums triggered by a lower standard of proof, undermines that rehabilitative goal and shifts the focus towards punishment for an unadjudicated offense.
It seems like he's highlighting a potential conflict between the goals of rehabilitation and punishment within the supervised release system.
Right. And he pointed out that in some cases, the maximum penalty under standard recidivist statutes, which deal with repeat offenders, might actually be lower than the potential life sentence under 383K after a supervised release violation.
So he's arguing that this revocation provision is potentially even harsher than the punishments for repeat offenders in some situations.
Yeah, which is pretty striking. Now, throughout the arguments, the justices were peppering both sides with really tough questions, trying to get to the bottom of this complex issue.
It sounds like they were really engaged, which is always a good sign.
Oh, absolutely. Justice Sotomayor, for instance, zeroed in on whether a judge could essentially impose a much longer sentence based on a finding made after the original sentencing, using that lower preponderance standard. And she drew that key distinction between parole and supervised release that we've been talking about.
Because with parole, the original sentence acts as a ceiling on how much time someone can serve. With supervised release, a revocation could lead to more total time behind bars than the original sentence.
Exactly. And Justice Alito seemed to be wrestling with the broader implications of Haymond's argument, wondering if striking down this mandatory minimum provision could unravel the entire system of supervised release as we know it.
So he's thinking big picture about the potential ripple effects of this decision.
He is. And Justice Gorsuch, he really dug into the fact that Congress has shifted away from parole, pressing the government on why that shouldn't affect how we analyze the jury trial, right, in supervised release cases. He even threw out a pretty provocative hypothetical, asking if the Sixth Amendment would still be off the table if the mandatory minimum sentence for a violation was the death penalty.
Wow, that's a heavy one. I'm guessing that really put the government's position to the test.
It did. They had to come up with a nuanced response, saying that while other constitutional protections like due process might kick in for such an extreme penalty, the Sixth Amendment wouldn't necessarily apply.
That's definitely something to think about.
Yeah.
Now, Justice Breyer, as you might expect, was exploring the boundaries of the Apprendi rule, really trying to pinpoint where it applies and where it doesn't.
Right. He was trying to figure out if a jury finding is needed, even if a fact only allows a judge to exceed the statutory maximum, not necessarily requires it. So even if the total time behind bars doesn't go beyond the original sentence plus the supervised release term, he seemed to be suggesting that once a judge's finding can push the total potential sentence beyond that statutory maximum, a jury should be involved.
It's almost like he's trying to find the tipping point where the stakes become high enough to trigger the jury requirement.
He is. And Justice Kagan, she kept coming back to that parole versus supervised release distinction, too. She emphasized that unlike with parole, where the original sentence sets a hard limit, a judge's finding during supervised release revocation could result in a longer total period of supervision and incarceration than what the jury initially imposed.
So she's saying, hey, this isn't just about losing the privilege of early release. It's potentially about being locked up for longer than a jury ever contemplated.
Right. And she also questioned whether simply having a jury make the violation finding at the revocation stage would actually fix the constitutional problem.
So she's not convinced that just shifting the fact-finding role to a jury would solve everything.
Nope. And Justice Kavanaugh seemed to be focused on whether this was more about taking away a benefit or imposing a new penalty. He suggested that revoking parole is like the government saying, oops, we gave you this early release benefit, but we're taking it back. But with supervised release revocation, especially when it means tacking on more time to the original sentence, it feels much more like a brand new punishment.
Which gets back to the question of whether this whole process is more like a continuation of the original sentencing or the start of a new punitive phase.
Exactly. And he even asked if there would still be a constitutional issue under 383K if the mandatory minimum was removed, focusing on the potential for a life without parole sentence after revocation.
So he's trying to tease apart whether the constitutional problem lies solely in the mandatory minimum or in the structure of supervised release revocation itself.
He is. And last but not least, Justice Ginsburg had a sharp question for Haymond's lawyer about why he was willing to concede that the general revocation provisions are okay, but drawing a hard line at the mandatory minimum cases. She also pressed him on why he wasn't fully embracing the government's suggestion of having a jury make the factual finding that triggers the mandatory minimum.
It sounds like she was testing the limits of his argument, trying to see how far he was willing to go.
Definitely. And Lund's response was that implementing a jury system in revocation proceedings would be incredibly messy, with different standards of proof and a host of other potential legal complications.
So he's acknowledging the practical difficulties of that proposal.
He is. All right, so we've walked through the government's position, Haymond's arguments, and some of the key questions from the justices. Now it's time for our favorite segment, the 10th chair perspective. We put on our hypothetical Supreme Court robes and offer our own take on the case.
So what's your gut feeling on this one? Where do you come down? Expert speaker as the 10th chair. You know, after listening to all those arguments and the back and forth with the justices, I have to say I'm really wrestling with the tension between the traditional discretion that judges have in managing supervised release and those bedrock constitutional principles about the role of the jury in determining facts that increase punishment. This whole mandatory minimum scheme in 3583K just feels different, like it departs from the more flexible, rehabilitative goals of supervised release. It's hard to escape the argument that imposing a 5-year mandatory minimum based on a judge's finding using a lower standard of proof is essentially adding punishment for the original crime without the same due process safeguards that were required for the initial conviction. So you're leaning towards Haymond's side, seeing this as a potential violation of his Sixth Amendment rights. Yeah.
Expert speaker as the 10th chair. I am.
The government's analogy to parole revocation just doesn't sit right with me. The potential for supervised release revocation to result in more total time behind bars than what a jury originally authorized makes it feel like a much bigger deal, like a new punitive phase, rather than just the loss of a benefit. And that breach of trust justification just doesn't seem strong enough to overcome the potential for serious constitutional violations. At the end of the day, I think this case forces us to really grapple with the balance between judicial discretion and post-conviction supervision and the fundamental right to a jury trial when someone's liberty is on the line. It's a tough one for sure. And as we've seen, it raises some really fundamental questions about how our justice system operates, especially in the post-conviction context.
Absolutely. This deep dive into the oral arguments in United States v. Haymond really lays bare the complexities of this area where established sentencing practices bumped up against core constitutional rights.
The justices were clearly wrestling with where to draw that line, with how much power judges should have to impose additional punishment based on findings made after the original conviction.
And it highlights the ongoing debate about finding the right balance between the need for effective supervision of those released from prison and ensuring that everyone's constitutional rights are protected.
It's a conversation that's not going away anytime soon, and we encourage our listeners to continue grappling with these issues as the Supreme Court works its way towards a decision in this case.
Because this is a case that could have a major impact on the lives of countless people who are navigating the challenges of re-entry and trying to rebuild their lives after serving their time.
We'll definitely keep keeping a close eye on this one, and we'll be sure to keep you updated as things develop.